Hi, folks. It's Denise Howell here. And next up on This Week in Law, we've got Iyaz Akhtar, we've got Jonathan Frieden, and Evan Brown. Groupon's patenting April Fools, and Amazon hasn't gotten its licenses. Is Eric Gardner being sued by Righthaven? No, not anymore. Thank goodness. We'll check into that and more here on TWiL.
Netcasts you love.
From people you trust.
This is TWiT.
Bandwidth for This Week in Law is provided by Cachefly at CACHEFLY.com.
This is TWiL, This Week in Law with Denise Howell, episode 105, recorded April 1, 2011, Accidental Sewage. This episode of This Week in Law is brought to you by Carbonite Pro, online backup for your law office. Carbonite Pro backs up your files automatically and continuously, so you're always protected. Learn more and try it free at carbonitepro.com. Hello and happy April Fool's Day. Welcome to This Week in Law. I'm Denise Howell. We're here for episode 105 of our show, and we've got some great guests to talk about things that can't be for real, can they? Here on April Fool's Day, we've got Iyaz Akhtar up there in the TWiT cottage from This Old Nerd and Tech News Today most recently. Welcome to TWiT, Iyaz.
Thank you. Just a quick warning to everybody. I was a lawyer. I took those tests and everything, so I'm extremely rusty because I somehow wound up in the tech field. But I kind of know what we're talking about, so just be aware.
It's great. It's great to have you in the TWiT family. For anyone who's not familiar with Iyaz, he's been doing yeoman's work on Tech News Today for some time now and has actually moved himself west to the sunny state, California, to be part of TWiT. And we're thrilled to have you here on TWiL. Thanks for joining us.
Thanks for having me.
Also with us, a return panelist on This Week in Law is Jonathan Frieden. Hi, Jonathan.
Hi, Denise. Thanks for having me back.
Great to have you again. Jonathan blogs at ecommercelaw.typepad.com. How mad are you at the Greenberg Traurig folks for scooping up ecommercelaw.com out from under
They
you?
got to it first.
Did they? Okay, good.
It was a little irritating, not too mad.
That's good.
I also realized that apparently the second theme of today's show is goatees, so I fit in with that theme as well.
Oh, wow, I missed out.
I know. We've got Iyaz and Jonathan sporting the facial hair. How about you, Evan? Have you? It's too early for you in the year, isn't it?
It is. And, I mean, sometimes I'll try to mix it up a little bit and, get something here and there. It's just because I have so much anxiety. I guess I want to change things up all the time. Nothing here, but I would have planned and prepared for that if I had known. So it's I'm the one missing out. That's for sure.
And as am I. So I'll keep you company at
Okay.
any rate.
Great.
So, of course, it is April Fool's Day, and here I was thinking that, the jokes that people do each year, there aren't going to be any that have a real legal slant, so we can just go straight into some stories and substantive stuff. But then I hear from Evan this morning, and I check out Groupon's April Fool's offerings, which are all about the law, intellectual property law to be exact. Groupon claims to have patented the entire April Fool's concept. Evan, you want to tell us about this? It's pretty darn funny.
Yeah, this is great. Groupon, always, the ones to have a sense of humor, probably still remembering kind of the fallout they had from some of their advertising with the Super Bowl. During the Super Bowl, some of those ads that many felt were in bad taste, kind of making fun of some causes. Taking a much more lighthearted approach to their promotion here, but doing it in a way that can still poke fun. So maybe they figured out a good balance of how to make fun of stuff without making people angry. I suppose maybe there are some patent lawyers and some strict patent kind of people who are upset about this. But what they've done is they have purported to file well, first of all, I think they're claiming trademark rights in the the term April Fools, and then they also have filed a patent application, which is styled "A System and Method for Performing Jocular Activities on an Unsuspecting Individual on a Particular Date." And so if you go, I don't know if we can get the link to this. It's on the screen now if you're watching. If you're listening to this after the fact, I'm sure if you do a Google search for Groupon April Fool's patent, this will be the first result. But nice illustrations of the claim showing the conniving one over here, very appropriately with a cloud, a thought cloud to the left of him, thinking about these unsuspecting folks that he can play the April Fool's trick on. So this becomes meta pretty quickly because it's a patent about April Fools, and of course it's an April Fool's prank itself. But it's really fun to go through and read some of this very dense language, that describes the background of the invention and some of the descriptions of the drawings. And then when you get into some of the claims, it really is fascinating. And I won't belabor it, but it's quite worth one's time to go through and read in great detail in the nomenclature that patent lawyers use, describing this method for misleading an unsuspecting individual whom you are companions with on a day like this on April Fool's. So good job, Groupon. Proud to say that you're representing Chicago very well.
Yeah, and whoever came up
the
with
law is so full of absurdities. It's good that they've managed to hit on that and actually pull it out for
They have done it very artfully, artfully for sure.
Yeah, whoever did those drawings, I mean, if you've seen enough patent applications, they don't usually look as nice as those. I mean, usually it's like stick figures or like figure one, and they have the vague concepts there. But these look like little cartoons, and the flow chart looked nice. So I like it just as an art piece myself.
Yes, and there's actual emotions on the people involved. And
you can see the scheming right there on his face.
Well, and then they have the whole page of cease and desist letters they're supposedly sending out to companies who, through their own April Fool's escapades, have violated the patent. Maybe we could show one of those. There was one to YouTube about their viral video from 1911. Do you think they're really sending those out? And did they really file the patent?
That would be really interesting to see if they actually bothered to put it to the USPTO. I'm sure there's actually a whole bunch of those coming to PTO right now. They're just going to oh, great. I wonder if they even look at stuff filed on April 1st. It might be very depressing. Working as a clerk there, going, oh, no, this is not real, is it? A method by which you can prank somebody? If this was an app, I guess you could try to patent it, but it's not. Just a method.
Right. Well, how about this? Can this be for real? We got a heads up from viewer Niels Elsenheimer, who read that Google was awarded a patent related to the Google Doodles. And this one's actually for real, I believe. Maybe it was filed on April Fool's, but I don't think so. A system provides a periodically changing storyline and or special event company logo to entice users to access a web page. So Google, which does a great job with its Google Doodles, obviously, and people love them, now thinks they should be able to patent that. Niels wonders how it's possible to patent it, even though they have been showing up since 1998, the Doodles themselves. I don't think that, if it's your own prior art, that's really an issue. Maybe you're just late to the game in filing your patent application. Jonathan, any thoughts on this one?
Well, of course, Denise, every time I'm on the show, you go to me first with the Google matter. Denise, since I represent Google, I can't really comment on the matter. But I think you know where I come out on this particular patent. I agree with Google.
Yes, absolutely.
Completely and entirely.
In your view, they can do no wrong.
Absolutely.
All right. Well, I would say so say we all, but fortunately, we're not all in that boat and can laugh at yet another seemingly absurd patent.
It just shows there's a lot of tired people at that office. Need to pump some more money into the PTO if they're granting this. I mean, it looks like a joke, but I mean, they tried it and it worked. I mean, that's pretty impressive. I mean, that's some guts.
Right. Bert, can you double check on Evan? I'm not sure if we lost him or what's going on here. I'm getting strange texts from him on the side. So what I'd like to jump into now, because I've been marveling at the unreality of it all week, pretty much, is this Amazon Music cloud-based service that we have been talking about on TNT yesterday, and lots of folks talking about online and in the Wall Street Journal, etc. First of all, can it be for real that Amazon thinks that a cloud-based music service is really what people want to go to these days? I'm kind of thinking that they missed the bus on this a bit, that it might be a little too late. That, you know, I mean, from my own personal standpoint, I don't want to upload all the stuff that I've been listening to for years on iTunes to the cloud, because it's just too cumbersome. And, you know, this is going to be a for-pay service once you get beyond 5 gigs. And I guarantee you, people who have been collecting digital music for many, many years have more than 5 gigs of material. And frankly, things like Pandora have actually absolutely ruined me for this kind of cloud storage model. Maybe that's not true for everyone. What do you think, Iyaz?
Well, I mean, for things like Pandora, sometimes they don't have rights to every artist like that I might have to in my collection of CDs. I might have a whole bunch of weird things. Like when I was in college, I was picking up CDs left and right from unknown bands, and there's no way Pandora has access to that kind of stuff. What I'm more intrigued with is the whole thing where they think they don't need a license. I mean, their concept is they have their own file, right? You have your own file that you upload to their servers, and then because you're accessing your own file, that's okay. Do you think this, what about all the technical aspects of this? I mean, doesn't this seem like no other company will want to try this because of all the storage requirements you would need? Because if 100 people wanted to listen to the same song, they have to have 100 copies.
Right. That was the problem way back in the day with mp3.com. They had the logical concept that if you could demonstrate, if you could put your CD in your CD drive, and they had software that could confirm that, yes, you actually own that disc and have the rights to play it, then they were going to have one central storage location that people could access. So they wouldn't have to replicate every single user's version of that piece of media. That got them in all kinds of legal trouble. So as an attempt to get around that, Amazon appears to be offering a service that's going to allow users to upload their individual libraries and then store them on Amazon's vast S3 infrastructure. But when you begin to get into the licensing issues around all that, it's not at all clear that Amazon has permission from the content industry to be able to permit users to do this. And they certainly have not been buying into that with their comments this week. Jonathan, any thoughts on how this is all unfolded? And is it completely unbelievable that Amazon would go forward with this without getting all the licensing in place?
I don't know that it's unbelievable. I think that what we saw is after the announcement of the service being offered, then we saw reports of Amazon entering into negotiations for the licenses that the recording industry, the music industry said that they needed in order to go forward. So whether one happened before the other and that was the same order that it was reported, or whether they had been in negotiations and they announced the system or the service prior to completing those negotiations as a negotiating ploy, I don't know, but we in some of these stories, they go back to the Second Circuit's Cablevision decision as being support for the fact that the Amazon service is legal. I agree with you, Denise, that I'm not so certain that Cablevision says that, but I think that it does provide some support for their position. I think ultimately Amazon has taken an aggressive position in the hopes that it gives them additional leverage in their negotiations, because I think that what they're trying to communicate to the licensors is we're going to go forward one way or the other based on Cablevision. If you want any additional money out of it, then you better come to the table and talk to us now.
Back up for a minute for folks not familiar with the Cablevision case or who don't remember it, and give us the context there. What did that decide?
Well, In Cablevision, that was a second well, it went up to the Second Circuit, and it was a decision based upon a DVR case where it was actually a remote DVR service where folks were taping or recording video to a remote service. The Southern District of New York, they were sued by the content providers. The Southern District of New York agreed with the content providers and found that Cablevision's remote DVR service infringed the copyright of the content providers in three ways. First of all, by the initial storing of the recorded content. Second, by the copying of the content to Cablevision's servers. And third, by transmitting that data, that content, from the servers to the customer's set-top boxes for viewing purposes. And that infringed on the right of public performance. The Second Circuit actually reversed the decision and found that the initial buffering of the content doesn't constitute actually making a copy of the video, and that the customer, rather than Cablevision, who makes the copy of the program, which makes the service similar to TiVos and VCRs and dissimilar from an independent copying. So it was more like time shifting or VCR use, which was a legitimate and legal use of the content than it was making an additional copy for distribution.
What do you think, Evan? Is Amazon going out on a limb here?
Well, sure they are, but they have every reason to do this. And, you know, I wonder if secretly they're hoping that Google and, you know, Apple will just go ahead. I guess Apple be a little bit more bold. You know, it's already doing something similar to this. It's not really promoting it very much. I wonder if Amazon is also hoping Google will just be as bold as well, because, you know, what is the content industry going to do? Is the content industry really going to sue everybody and, you know, cut off this, you know, this avenue of the ways that music may be enjoyed? I'm not going to put it past them. You know, they've made some decisions as far as their overall strategy that I don't necessarily agree with. You know, they've done that in the past. So, I mean, Amazon has the weight. It has the, you know, it's in a position to be able to do this, to be able to take this risk. And at the same time, they're hedging a little bit, as Jonathan pointed out. You know, they say that they're still trying to work out these license agreements. It's not the best way to be in the good graces of the person that you're trying to negotiate a license with to, you know, essentially snub your nose at it and go ahead and do something like this. But, you know, clearly if they can do this, it's going to enhance their, I mean, obviously it's going to enhance their profit margin, make that much bigger if they don't have to pay additional license fees like this, so they can offer the service to individual users in a way that's friendly to the consumer. And I think if the content industry is smart about all of this, they can realize that you know, this could very well encourage and ultimately enhance the sale of digital music if there are additional ways for it to be easier to consume, separate and apart from, you know, streaming alternatives like Pandora and others like you point out. I was a little surprised, Denise, to hear you express some skepticism, you know, as to whether or not this is something that people would want to do. I don't know. I hadn't you know, come up with any kind of doubts like that. There's something just, you know, really cool about having your own music collection. And this is a throwback all the way, you know, to when people started collecting records, I imagine. I'm just kind of speaking from my own psychological insight onto all this. I mean, it's really neat to have your own collection, your record collection, or, you know, going through the 1980s, you know, your tape collection into the 90s, you know, CD collection. So this seems to be like a natural extension of that. There's something, you know, inside that would make me resistant to just putting everything out there as a streaming service and not having some kind of control or minute, quote unquote, ownership over something associated with my music collection. And in any event, there's going to be so much more storage and more bandwidth. You know, the practicalities will sort themselves out, you know, through time, in one way or the other. So Amazon's just doing what they want to do.
I think different people feel differently about, you know, how they want to enjoy their music, but it comes down to something we've talked about a lot on the show, and how, you know, our conventional way of thinking about copyright as opposed to digital artifacts doesn't make much sense today.
Nope.
Yeah, there was a comment from Jack Valeni a long time ago at the first D conference, back when he was head of the MPAA, and someone asked him about, it might have been Mark Cuban, got up and asked him, why can't I make a backup copy of my DVD? The things are ephemeral, they get scratched, they're delicate. I need a backup. I've bought this thing. I need to be able to play my media in the event something happens. And Valenti looked at him deadpan with a straight face and said, if you had a piece of fine crystal and it broke, you wouldn't have a backup of that, would you? So it's for them, it's all about the actual physical device or the physical medium and not what we're all actually wanting to enjoy, the item itself that's stored there. And, I think as long as you have the access and permission to get at whatever music you want to be able to play, then if it's in the cloud, if it's streaming, if it's something like Pandora is pretty much fully sufficient for someone like me who doesn't necessarily want to spend a lot of time organizing and DJing and setting up playlists and stuff. But there are times when you want to play that one particular album and that one particular song, and so you want your own collection, or at minimum, the right to access that when and where you want to access it.
Denise, so back to your point about the whole collection and Evan's point about the whole collections thing. I mean, are you afraid at all about the whole access being denied because of contractual disputes between someone like Amazon and maybe someone like Sony? Let's say they had a fight, 5 years down the road, and now you've lost access to whatever Sony music for like a week or two. I mean, we've seen it with cable companies, when Fox wants to pull away from Time Warner because they're not paying enough royalties or whatever happens with that kind of situation. Do you have any fear about losing access based on large companies having just squawking matches?
Sure. And I think that people have lost access to their digital artifacts that they've purchased before and have had a lot of outrage about it.
Yeah, that sounds like the with the Kindle and the George Orwell estate. I mean, it's a little bit like that, with the rights holders kind of making a big issue about something and access being denied. So, but I mean, it just seems like it's a risk that's inherent with the technology. And, I guess there's always a risk that your record collection is going to get lost in a house fire, clearly of a different nature. But, I'm wondering statistically whether, your record collection getting burned in a house fire and getting melted and, lost with all the rest of the fine crystal is the same kind of risk as, Amazon and Sony getting into a fight a few years down the road. Is it worth the risk of that convenience and the access to all of this stuff? Is it a rational, economic, and just kind of overall reasonable decision to make to be supportive of a model like this? Who knows? I certainly don't.
There were a couple of other things that made this story a great April Fool's Week story. One was this whole sort of concept that I can't believe we're still struggling with the notion that what people want is to be able to play the stuff that they've bought the right to play, where they are, when they want to play it, from whatever device, et cetera. And we're still, in the midst of the legal thicket that will someday enable that to happen. The other couple of points I thought were pretty interesting was that the Wall Street Journal came out and made this blanket statement about the Cablevision case that Jonathan discussed being basically Amazon's safe harbor here, that it would shield them and protect them, when I think that really the use case of what's going on is quite different than simply having an in-the-cloud DVR service for one's cable recordings. And finally, when you dig down into Amazon's MP3 download service, terms of service, and I know, we're supposed to be the people who always dig down into these things and pay attention, right? Well, we do when a controversy comes up, like everyone else. People don't pay, even lawyers don't pay that much attention to what all the various services terms are. I went and took a look and thought it was fascinating that Amazon tells users they have the right to copy, store, transfer, and burn the content that they buy from the Amazon MP3 music download service. I would think those are some pretty broad statements and potentially fighting words. What do you think, Evan?
Well, I guess so. I was really glad that you noticed that and that you mentioned that in the piece that was in Ars Technica where you were quoted about this past week. You know, that certainly does seem to have some to give us some insight into what Amazon was thinking. Are they trying to establish some you know, course of, you know, some industry standard or something like this, saying, look, we allowed our users to do this for years and years, so record companies, why are you now coming to us and saying that there's some problem with this? You know, you didn't complain all this time, why are you bringing it up now? As if to say that the record companies had somehow waived their rights to enforce a new licensing mechanism or to extract this additional pound of flesh, you know, when they're trying to do this. So, I mean, it makes sense from a conceptual level. I don't know how much attention a judge would pay to this, you know, if Amazon were to come in and say, you know, I just don't know how this would get teed up procedurally, you know, or even, you know, once it got teed up appropriately procedurally, to even know how much attention a judge would give this substantively, to say, oh, well, Amazon, you were doing this all along, so therefore it's okay, because it's, you know, these are just, you know, really, the record companies would at least say that these are very important rights and that their waiver shouldn't depend on some obscure couple of lines in Amazon's terms of service that, as we've already established, no one reads anyway. But yeah, I like it, and you know, it's certainly it's certainly smart on Amazon's part if they're doing that, and I have no doubts that, you know, that this certainly does inform that desire for them to want to have to grant these broad rights to their users, so that it's not so strange and alien of a concept once they can launch a service like this.
Right. I wonder if Amazon might try to make an argument at some point that, hey, you know, you bought into our service, you agreed to make your content available, and you were well aware, although no one reads terms of service, that this is what we represent to users. I don't know. It strikes me as an interesting little tidbit there. Jonathan, do you remember back in the Grokster case when our soon-to-be Solicitor General here in the United States, Donald Verrilli, made a statement on the record about users having the right to back up their media and how controversial that was? He was really the first person,
Denise.
yeah, from that side of the table to say, oh, yeah, you know, rip, mix, burn, dudes.
And I think all of this, Denise, I think all of this underscores the inadequacy of the Copyright Act as it exists. I think most of it dates back to 1908. Technology has changed quite a bit in terms of the distribution of content and media over the last 102 years or 103 years. So I think it may be time for Congress to step in and clarify some of these issues. I was particularly interested in the fact that there were so-called you know, IP law experts who said that Cablevision protected Amazon absolutely, and they were certain of it, whereas I think there is some doubt, and I think that where you have confusion as to what the law allows, I think it's a situation where technology has gotten to a point where the law has to be updated to account for the better technology over the last 100 years.
Yep. Well, I think it's a fascinating story, and we'll continue to watch it unfold. Anybody have any final thoughts before we move on to another instance where I'm shocked that permission was not sought beforehand?
Sure.
Anyone else on Amazon?
Sure, real quick. If you want to actually back up your stuff and you don't want to go through this whole Amazon thing, you can do this, by the way, at your own house with software. I think it's called Libox, Libox. And you can just run your own cloud. So if you don't want to even deal with this whole thing with uploading your music and you still want to access, you can still do that. So on the tech side, it's very, very possible to have access to your stuff no matter what, even if everybody's all fighting on the other side.
Right, and even if it's still legally controversial, whether you have the right to make copies for your own personal use in that way. Right. Because I think it still is legally controversial. Okay, so the other company where you just go, that just can't be for real, is the Time Warner Cable app, which I can't remember if we've mentioned on the show before, but as a Time Warner Cable subscriber, I was pretty excited that they came up with an iPad app, and I thought, oh, great, you know, still staying in the time and place shifting mode. I'll be able to, when I'm not in my home, to watch the cable programming that I pay a whole lot of money for. And no, that's not actually how the app works. You know, for anyone who's been paying attention to that, you have to be in your home and on your Time Warner Cable modem for the app to work. So it's a pretty innocuous instance of place shifting, time shifting. It certainly doesn't shift your place too much. It shifts your device from the TV to the iPad as it is right now. But still, even though it's innocuous, apparently the channels that are carried on the Time Warner service don't think so. And they think that this is an entirely new broadband platform and have the same kind of complaints against Time Warner as the record labels have against Amazon, that they went ahead and did this without getting all the proper permissions. Iyaz, are we seeing a trend here?
I think we're just seeing a repeat of what the music industry did and what cable's doing now. I mean, well, not cable, but what television networks are doing. It's more annoying than anything, I think. They're going to fight no matter what. They always want rights every which way. Not rights. They want to get paid for every single thing on every instance of a download or stream of this thing. And the weird thing is, I was figuring out, okay, if you use a Slingbox or something, that's okay. It's almost like, where is the line? Like, how close do you have to be attached to your set-top box? So if this was actually built into hardware and it could stream to your app on your iPad, that would be fine, apparently. But if it's being streamed directly through the internet, that's crazy. So it just seems like I'm just wondering where they think the technical line is such that you should be able to access these things as if you were receiving it on a cable box.
Right. That's an excellent point. And I think it echoes what Jonathan was saying, is that when we get right down to it, the technicalities shouldn't matter all that much, should they? It should be the functionality. Yeah, what do you think, Jonathan?
Well, Denise, the reason that the technicalities matter to the content providers here is that they don't get ratings credit for shows that somebody's watching on an iPad. And since ratings numbers are what determines advertising rates for the folks that are still tied to that, and they're going to have to get away from it eventually anyway because none of us watch commercials with our TiVos anymore. But because advertising rates are tied to those Nielsen or People Meter ratings, they have to care about it. It goes to the fundamental, I guess, financial model for the business. And in this instance, the Time Warner cable issue comes down to differing interpretations of their carrier agreements as to whether these rights were already granted in those agreements or not. So the reason why they care is the ratings and the advertising rates. And it really comes down to not an interpretation of law, but an interpretation of the written agreement between the parties.
Well, that's really interesting that that's related to advertising in that way. And it's on this point where you can draw a line to the do not track controversy that's going on with, browsers and all of that stuff, because to the extent that you can't track someone's behavior online, what sites they're going to, who they're talking to, and all that, it's more difficult to monetize that attention. It's interesting to see the parallels between all of that and the way that really advertising kind of is, that as a revenue vector is motivating a lot of this behavior, and not so much something that's inherent when it comes to, the ownership of intellectual property rights. Is there anything wrong with my analogy there? Does it break down more miserably than what I could try to find a way it does?
I thought it sounded pretty good. What do you think, Iyaz?
Oh, boy. I mean, that just sounds like you could just negotiate and say, hey, listen, fix the app so we can receive tracking information if they really want it to be that way. But it seems like they want to just say, look, you cannot broadcast this at all. And I guess that's their first negotiating point. And then they'll go back and forth. And hopefully, if they want, they can have the tracking data. And the weird thing was, Time Warner only had a limited amount of networks on this application in the first place. So, I mean, maybe they foresaw there'd be problems here, or they wanted to test some companies. I mean, I know News Corp and Viacom were ticked about this, and they had cease and desist letters. They can fix this in software. I don't understand why this is such a horrible point that had to take these networks right off the application.
Right. And the thing that depresses me about watching all this unfold, as well as Hulu and Hulu Plus and all of the different ways that the television industry is starting to enable its material to be consumed online or via the internet in various ways, is they seem to be focused on fixing the bug that is commercial skipping. That, the more we go into various alternative modes of distribution, they're going to make darn sure that what TiVo and Replay TV started all these years ago gets itself worked out, that we're all going to be stuck watching the ads. Jonathan, is that what it all comes back down to?
Well, it absolutely is, Denise, and it they have to do that in order to save the industry. We saw what has been happening to newspapers when the web came online, and people went to the web for news. They were getting essentially the same content they could pay for in a newspaper, and in many instances it was available for free. In most instances, it was available for free, and in large part, it's begun to kill the newspaper industry. And the newspaper industry had to move towards other models for generating revenue. And I think that in terms of video content providers, TV, movies, and the like, as we move away from a model that permits them to get advertising dollars directly or the traditional forms that they've distributed that form of media, if they don't find a way to keep control of it and monetize it, then they realize that the industry will die.
The weird thing is for streaming things like things on applications, I mean, wouldn't they have a different advertising model? Couldn't they put up banner ads, or they could have much more interactive ads because this is an internet-connected device? So you can have, you can have like iAds on there, or you could have just banner ads, or just anything that would show up. I mean, they could have a whole new model based on this internet system that for some reason, like, I mean, on Hulu, they get to dynamically change the ads. So why not just embrace this and just allow this to happen on a Time Warner app? Do you think they want their own apps, like the News Corp app, and they want the Viacom app? I mean, what do you guys think they are going for here?
I think they certainly want that. I think that maybe there is some grain of wisdom somewhere in their organizations that is telling them that their customers don't want that nobody wants to have to be beholden to several hundred separate applications to be able to access whatever it is they want to consume. And by the way, Tamahome in IRC has solved the commercial problem for the companies. So, here's our gift to you from TWiL. Play your commercials in slow motion so they look normal when you fast forward through them.
Isn't that great? That is awesome.
That's a great idea.
Yes. But the problem is you can't even fast forward when you're on a service that is, blocking your ability to manipulate the media like Hulu does. You cannot skip those ads. Or maybe you can if you are incredibly technically savvy, but who's going to really jump through all those hoops?
Then you violated the DMCA probably. So,
right.
Kind of stuck. That content industry, man, they were thinking ahead. They knew all this stuff in 1998.
They've known it all along, Evan. All right, so more ridiculousness and absurdity. LimeWire wants to not have to pay $75 trillion in damages. I don't think that there's any way, that any individual or company could be called to pay $75 trillion in damages. I don't think LimeWire could pay more than a couple $100,000 if they're lucky.
You could, liquidate Europe or something like that. That might work.
That's a great idea. But that's what the RIAA thinks LimeWire owes. Judge Kimball Wood has been reining them in somewhat, as is her job as the judge in the case, saying that they're limited only to a single statutory damage award from the defendants per work infringed for several reasons, including the absurd result which would ensue if they actually got an award per infringement. Jonathan, what do you think about this one?
Well, I think in order to place the absurdity of the suggestion that they would be entitled to an award of $75 trillion in the context, first of all, the judge in the case noted that the plaintiffs were suggesting an award which was more money than the entire music recording industry made since Edison invented the phonograph in 1877. And if you think about the amount of money we're talking about, if you were to take it in $1,000 bills and stack it, one $1,000 bill on top of another $1,000 bill, the stack would be 5,092.5 miles tall. So that's the size of the award that they're seeking in this instance. And it's a statutory damages award, and I think the judge is right to say that that's not the intent of the statute, for you to be able to come in and essentially get from a single defendant more money than exists on the entire planet of Earth.
Wait, now, were those bills stacked or were they end to end? Because that makes a huge difference as to whether this is reasonable.
It's stacked, Evan. Absolutely stacked.
Okay, then it is absurd.
Now, I've got a question. Way back when I went to law school, we had this thing called model rules, and you had to have good faith when you would make a claim like something like this. How on earth can any attorney write down on their complaint that this company owes them $75 trillion.
You do it with your little finger on your chin.
Oh, just I must have missed that. Was that just added in the last 2 or 3 years? I must have.
It's in the appendix somewhere.
Okay.
Or it's in the comments.
I'll go to the CLE next week and I'll find out.
In all seriousness, though, you do it under the Copyright Act as it exists in the United States today, and you do it with a straight face. And I'm worried that Judge Kimba Wood is putting herself out there as vulnerable on appeal by reining this in, because, you know, technically under the law, you're entitled to your statutory damages per infringement.
Yeah, as long as they don't bring up absurd
per
results.
work infringed. I never realized there was any ambiguity in this section. I'm trying to look at it right now. I have a book in front of me that, you know, it's intellectual property statutes. Where is it, Jonathan? You know, it's section 5 something.
Yeah, I have it on my iPhone app here.
Section 504. Oh, geez, you got an iPhone. Here I am with my book. You're making me look silly.
Evan, I'm a technology lawyer.
Which technology will win, the search or the paper?
Maybe IRC will ride to our rescue. Akhtar, you're absolutely right. And Judge Wood writes about the absurd results clause and is relying on it. But still, I mean, you know, I think that anybody with a straight face would look at this and say, yeah, that's an absurd result. But you never know. I mean, it is at odds with the actual way that the statute has functioned in other cases. So, you know, I think LimeWire can absolutely, you know, if you're their lawyer and you're being a zealous advocate and you're also concerned about being in good faith and not getting yourself sanctioned for doing something that, you know, is so amazingly outrageous and not in accordance with the way the law works, you go in and you make this claim. You do it every day.
I think to defend it, wouldn't the entire oral argument be like, come on. It's not possible.
That can't be for real.
And that would just walk away at that point.
Yep, wow. Absolutely. Well, Evan, did you dig anything up, or shall we move on?
Looks like it's section 504C1, and it's saying that you know, an award of statutory damages for all infringements with respect to any one work for which any one infringer is liable individually. I've just, you know, I've always assumed that it was beyond reasonable dispute that language for one work meant that you're entitled to one award of statutory damages per work infringed. So you've got one work and there are 1 million copies made of it. Well, you still can only recover statutory damages for that one work.
Oh, this is the express line, what an item is. If you have 1,000 bars of soap,
that's right.
Is that one item or not? Okay, that's...
Yeah. Well, I think where the problem comes down is Evan, I think there's a dispute, and I'm not sure what the Seventh Circuit says on it. You may be right in terms of the Seventh Circuit, but I think there's a dispute as to whether or not that statutory damage award is a per work or per infringement of work. And the statute is not written so that it's clear. You know, when they go back to the Copyright Act to revise it and update it, maybe they should clarify it. But I think that there is an argument in some jurisdictions that it's a per infringement statutory award and not a per work statutory award.
Yeah. Well, yeah, that must be where it comes from. I just remember being excited about, you know, a bunch of zeros when I had been practicing law for about 2 weeks, you know, and had my first copyright case, and then I realized that, well, you know, the world is much more cruel, I guess. I can only get, you know, $150,000.
Yeah, much more cruel.
Poor Evan.
Well, on the other side of the spectrum, you know, we're talking about people getting sanctioned for doing things that are not okay under the law. It's good to see that ACS Law is facing that kind of penalty. This is the company that brought one of those mass file sharing infringement liability cases, threatening people with court actions if they did not make settlement payments of up to £500. This was in Britain for their infringement. They've gotten royally slapped around, slapped around over there in the UK. And the latest is that they're now going to be liable perhaps for payments running to more than £100,000 for their tactics in that case. So NACS law, you know, aside from the monetary sanctions they may face, of course, they have not been popular among the web denizens. They've been hacked, they've been DDS'd, they've been, anything and everything that people can do to them has been thrown at them. So it's good at least to see that kind of check in the legal system is still in place and will be enforced from time to time. Here in this case, we're seeing it. Iyaz, any thoughts on this one?
It just happens to be across the pond, though.
Yeah,
I want to see that happen here. This kind of thing, I think the Righthaven stuff is kind of close to this in the United States. So I hope that this kind of thing happens with Righthaven a couple times.
Yeah, and you see it's trickier here because, here we have the American rule versus the English rule when it comes to the payment of costs and attorney's fees. And I think that's what you're alluding to, Iyaz, right? Maybe when you're saying, yeah, this is across the pond. In the U.S., generally, unless, you have a contract with somebody that says loser pays the winner's attorney's fees, or there's a statute that says the loser pays the winner's attorney's fees, each party pays their own attorney's fees under the American rule. It's different over there in England, and that seems to be kind of coming into play here. Now, the Copyright Act, and, we should all be grateful for the second opportunity during the show to get into the interstitial parts of the Copyright Act talking about, the award of attorney's fees. It says the loser pays if you're the prevailing party. And that's what the Copyright Act provides if you've registered your work in time, and there's a bunch of other conditions that have to be met here. But my experience has been that the judges are here in the U.S. are unwilling to award costs and attorney's fees unless there's really an adjudication on the merits, to make, a real determination of whether or not there was copyright infringement here. I've been involved in more than one matter representing defendants accused of infringement, and this is just so irritating when plaintiffs do this. They'll file the lawsuit. They'll even, get into some discovery and all that stuff. We have to really, think about the case, mount a defense, incur costs and attorney's fees, and then, they'll just withdraw the case. They'll just voluntarily dismiss it. And then it's very difficult. The case law supports the judges when they make these decisions. It's very difficult to get a judge to award attorney's fees when the plaintiff just kind of goes in, muddies the water a little bit and then decides, oh, well, I didn't really feel like prosecuting this copyright infringement action anyway. So that's one point in which the Copyright Act kind of helps defendants who are you might say, the victims of trollish plaintiff's behavior, but it doesn't really go quite far enough, I believe, at least when I have my defense lawyer hat on, thinking about these things.
Right. So I want to get into talking about Righthaven in a minute. Jonathan, before we go to that and to thanking one of our sponsors, do you have any thoughts about ACS law as we close that out?
Well, and sure, just to go back to what Evan was talking about, the problem with the copyright statute is that the attorney's fees provision of the law is written in a manner that makes it discretionary with the court. If the law were changed to make it a shall, to replace a may with a shall, then the court would be required to award reasonable attorney's fees to the prevailing party. And it could even be done such that it's a mandatory provision with certain guidance given to courts. For instance, it should always be the case that a plaintiff who brings a copyright infringement action in bad faith should always end up paying the defendant's attorney's fees and costs associated with that litigation. But unfortunately, because of the way the statute is written, that's not always the case now.
Mm-hmm. Yeah. Well, a lot of people feel that way about, the entire United States judicial system, that we should just switch over to the British way of doing things and make it so that, you really have to stand behind your claims. And if you lose, you pay the other side's attorney's fees. But we're a long way from being there.
We love litigation too much. It would really stifle the impulse to file a lawsuit if you knew that you really faced a fair chance of having to pay your opponent's attorney's fees if you lose.
Right.
And I think that you find in Commonwealth states, nations that follow the British form of litigation, you find less litigation. And I think that's exactly why, is that that if you bring a claim and you lose, you're going to end up paying the other side's attorney's fees. But we tend to be fairly egalitarian in the United States, and the biggest argument that comes up against following the English rule is that the English rule disproportionately disadvantages small litigants, so that if you're in a situation where it's a big guy against a little guy, the big guy can cover the fees of the little guy if the big guy loses, but the little guy can't cover the multiple big firm lawyers working on behalf of the big guy in the litigation if the little guy loses. So that's, I think, the reason in this country we haven't gone to the English rule.
Yep. Well, you know who doesn't discriminate between big guys and little guys?
Who?
Carbonite Pro.
Who?
Carbonite Pro. Sorry, that was a disastrous segue. But
I'm just going to have some tea while you're reading this ad.
Absolutely, have some tea. And one of the things that I absolutely love about Carbonite Pro is that I am here on my work computer doing our show, and it has, and I use Carbonite Pro to back up all my stuff. It has a function up on my little, I forget what you call this thing at the top of the Mac, but, little
bar.
icons. Yes, thank you, menu bar up at the top. Where you can click on the Carbonite Pro icon. It's a little padlock. And you can tell it to pause itself for 24 hours because you want to make sure that all of your bandwidth is being engaged in other things. Most of the time when I'm just working away at my computer, I don't pause it. I let Carbonite Pro run in the background because it is not a resource hog at all. It waits until your computer is idle, and it makes sure that all your stuff is backed up. Because, any kind of loss of data is devastating. It's devastating if you're a lawyer. It's devastating if you're a parent and you lose, your personal photos of your family. But when you're a lawyer or a business person, if you lose your client files and your billing records, that's just, end of story. You can shut your doors. But that's why more law offices and other businesses are using Carbonite Pro Online Backup. Your files are backed up automatically, so it really gets done, and it gets done continuously. Whenever there's a small change, Carbonite registers that and makes sure that those changes are backed up. They're stored safely and securely off-site. Plus, each employee can access their backed up files from any computer or on their smartphone with a free app. Prices start at just $10 a month, so you've got to start your free 1-month trial at carbonitepro.com. That's carbonitepro.com. They're great friends of This Week in Law, and we really thank them. All right, so another good friend of This Week in Law is Eric Gardner. He's been a panelist with us several times. And guess what? It can't be for real, but Righthaven sued him. Evan, you let me know about this. Why don't you tell me what happened? This was actually a little bit complicated, so I want to make sure that I get it straight. He is, of course, a freelance journalist. Eric Gardner is, and as you mentioned, he's been on the show with us at least a couple of times. He usually writes for The Hollywood Reporter, but he wrote one article for Ars Technica last December about the Righthaven stuff. And Righthaven is, of course, this company which is very closely affiliated with one of the Las Vegas newspapers. Is it the Las Vegas Journal Review or something like that, where the Las Vegas Journal Review has assigned all its copyrights to Righthaven, and the Righthaven goes out and sues everybody who, like bloggers and little small web publishers, for infringement when they will, copy articles now owned by Righthaven. Righthaven has actually expanded its efforts to work on behalf of the Denver Post. So back, if you remember, in the latter part of 2010, we spent a lot of time talking about the controversy over the TSA's invasive invasive screening processes, the TSA gropings and all of that wonderful stuff. So there was a lot of ink being spilled about that, a lot of pixels being put to the screen about that. And so it was the Drudge Report wrote about that, and the Drudge Report had, and make sure I'm getting all this straight, because it is a little bit complicated. The Drudge Report had written about that and had used a photo from the Denver Post and it became relatively iconic. It was a passenger going through a TSA screening point, really, we should just say in an intimate moment with the TSA screener. I don't know who was enjoying it more. And so
simply stated, Righthaven sued Righthaven sued the Drudge Report for using this photo from the Denver Post. Well, then here's where it gets kind of, multi-layered on all this. Eric Gardner wrote about that lawsuit that Righthaven had filed against the Drudge Report over the use of that Denver Post photo. And in his article that Eric wrote for Ars Technica, he used a snapshot, a screen capture from the Drudge Report using that photo, which had originally appeared in the Denver Post, which Righthaven was suing over. And interestingly enough, Eric Gardner had gotten that screen capture from the court filing, probably had logged on to Pacer, the service by which you can get federal pleadings and federal papers from the courts, had taken that from the court filing that Righthaven had made against the Drudge Report over this.
Probably was in their complaint and a matter of public record.
Yes, it was probably Exhibit A to the
Yes.
complaint. And you can log on and pay a few cents per page to get access to this information from our federal government. So that all happened back in December, and earlier this week, it was either Monday or Tuesday. This is how I found out about it. I follow Eric Gardner on Twitter. It's ERIQ Gardner on Twitter. That's how you spell his name. And he put out a tweet that said something like, "Oi, I've been sued by Righthaven." So of course that, wow, instant buzz right there. And so the world was abuzz with this news for about 12, 15 hours. We kind of got to sleep on it. And then the news the next morning was this great piece. Oh, this is just a wonderful journalism by Nate Anderson, again at Ars Technica, who informs the world that Righthaven had dismissed its lawsuit against Eric Gardner with prejudice. There was some confusion as to whether it was with prejudice or without prejudice, but it was
and that
with
means
prejudice.
They can't come back and file it again.
Yes, over forever. And essentially, Righthaven's version of this is, oops, sorry, we didn't mean to sue Eric Gardner because he's a journalist. It was, a clerical error or administrative error or whatever there. So
It's just
wonderful.
one of the many hundreds that we're filing, and it slipped through the cracks.
Yeah, yes. I mean, the details. The name of the defendant is just a minor detail. So it couldn't have happened at a better time of the year, that we can talk about this on April 1st, because it really does epitomize something that would have sounded like an April Fool's story, in any event. So it's just really pretty comical, kind of fun.
Yeah, absolutely. And we're so happy that Eric does not have to come into court and actually combat this thing.
Yeah, I mean, he's the most mild-mannered guy.
Yes. Who would want to do that? And, yes, he is a consummate journalist. And, as Nate Anderson writes up, he's doing exactly what journalists are supposed to do under the law and otherwise. So, Iyaz, any thoughts on this one?
Well, it'd be interesting if they actually went to court and they could say, hey, look, it's fair use. And then maybe Righthaven would have this nice big fat precedent against it, so they couldn't do this all the time. But I mean, I was more impressed that Evan was able to recall all the facts of this thing, because this was pretty complex. And I had to look up Righthaven myself because I was preparing for the show, and I just didn't know something like this existed. I mean, they just go out and sue everybody, and they obtain copyrights by doing this? Is that how that works?
No, they have copyrights, and they are trolling for uses of any of the material from the various clients they represent. It's a law firm in Las Vegas. So they're suing on
behalf of all these companies. It just seems, I just can't believe this exists, quite honestly. That's what I was just surprised. I thought this was a joke.
They're technically suing on behalf of themselves. That's what makes this even more trollish, is that, Righthaven is not the law firm representing someone else. They are getting by assignment the copyright. Yes. So then they are the plaintiff themselves. They own the copyrights by assignment that used to be owned by that Las Vegas newspaper and the Denver Post. So that's what I think is kind of raises the troll sensibilities in people, or the troll censor sensibilities.
Yes. The analogy to companies that come along and buy up patents simply for the right to sue over them. Same idea. Let's see, Jonathan, any thoughts on Righthaven and or its little mistake here?
Well, I think what it illustrates is the problem that you run into when you treat litigation like a mass-produced widget. In this instance, Righthaven, since March of 2010, has filed 261 lawsuits over Denver Post and Las Vegas Review-Journal material and 57 lawsuits over this particular pat-down photo. When you treat litigation like a mass-produced widget, you run into these problems. And I have a problem with the claim that it's a clerical error. The fact is that I have the complaint right to my left, and it is electronically signed by a lawyer who, under the Federal Rules of Civil Procedure, had to review this, and by signing it, indicated to the court, as an officer of the court, that it was warranted under existing law and under the facts of the case. And I don't see how you can do that and have it be strictly a clerical error. This is an error by a lawyer that filed something that shouldn't have been filed.
Yep. Well, here's one that I think really has to go in our bucket for can't be real, but it turns out that it is. And this is a web design firm that here in my backyard in Orange County, California, was hit with an award of $770,750 in damages to Roger Cleveland Golf Company because it helped create, host, and promote a website that sold counterfeit golf clubs. So it did not itself sell any counterfeit golf clubs or have anything to do with the site other than its hosting creation. And perhaps the promotion is the problematic area here, but just, web designer liability for someone who engages in counterfeiting strikes me as a very dangerous place to go. Maybe this is one of those, Evan, bad facts make bad law kind of cases, because the site in question was called, let me see if I can find the name, copycatclubs.com, which maybe should have put someone on notice that what they were engaged in was not the most up-and-up kind of e-commerce transaction. But the whole notion that the hosting/design company could be brought to the mat on this really raised my eyebrows. Am I just cutting this company too much slack? What do you think, Evan?
Well, I don't know. I did not actually read what the court said about this. I just read this article from the LA Times about the decision. And so to a certain extent, I'm thinking about this in a vacuum, and I don't really know how to, evaluate whether this could be a situation where it's bad facts making bad law. From a theoretical standpoint, I certainly know that it would make perfect sense in the appropriate circumstances for a web design company to be liable for the infringement or liability for the counterfeiting, the sale of counterfeit goods that its client is doing, because there's this whole idea of secondary liability for trademark infringement in the right circumstances. It's a little bit it's a little bit comparable to the question of conspiracy, working with someone to do this. So a web developer seems to be in a very good position to further this activity of the sale of counterfeit products if they are aware of it and have the ability to control it and actually do benefit from it in certain circumstances. So it could be that this web developer has gotten the short end of the stick, but reading the article, it sounds like they knew what they were doing, and maybe this was right.
Well, Bright Builders also did search engine optimization such that when you looked up the actual proper companies, golf clubs, you would find this copycat clubs site. So I mean, they weren't just developing the site; they were like gaming Google effectively, and that seems like they're kind of participating at that point. I mean, there was no reason to say, "Hey, look, every time I look up, golf company A, I should get this copycat." They should have. I think at the end of the article there was a quote here. It says, "It was so blatant we thought it was the perfect case to pursue. With a name like Copycat, a red flag should go up immediately." I mean, it screams like you should be really staring at what you're doing. You can't just go, "Oh, we're just going to put our head in the sand. We don't care what our clients do, and we're going to just go along with it."
Jonathan must have some interesting things to say about that, don't you, Jonathan?
I know. I'm wondering, Jonathan, do you think they could have disclaimed their way out of this? Over in the chat, Drock W says, maybe I can sue eBay for that fake Rolex I bought. Well, of course you can't. Could it have protected itself, do you think?
I don't think so in this case, and I think it's a web developer, and therefore it's an interesting story because a web developer was held accountable for what is essentially contributory trademark infringement.
Right.
But it's not, they weren't held liable because they were merely the web developer that developed the site. They were held liable because they were the web developer that participated in the infringement. And in order to be held liable for contributory trademark infringement, you have to intentionally participate in the infringement. And I think what the court found was, in addition to the name of the site, that made it clear that they were selling knockoffs of famous brand sites, and the SEO issues that Iyaz mentioned, that there were other facts that supported the conclusion that they weren't simply a web developer that, without knowledge of what the company was doing, developed a website for them. They were active participants and partners in the infringement, and that's why they were held liable. I think it's a case that's interesting for us to talk about now, but I don't think that it's going to affect the vast majority of web developers who do their work without encouraging, enticing, or participating in the infringement of a trademark.
All right. Well, thank you for your thoughts on that. Next, I want to discuss this new case against Facebook by the parents of Carolyn Wimmer, a woman whose dead body made the rounds on Facebook last year. It's interesting in a couple of ways. Number one, the parents are suing over viewing a photo of their daughter who is no longer with us. Secondly, they want Facebook to turn over the names of everyone who ever viewed the photo, and they want liability to attach to Facebook for allowing this photo to make the rounds. Of course, Facebook, again, we're talking about disclaimers in terms of service. Facebook does make people who upload photos represent that they have the rights to do so, et cetera, and in turn, it disclaims any liability for people who violate that. So do you think that this is of any concern? Jonathan, let's start with you.
Well, Denise, I don't think it's any concern to Facebook because, as we know, Section 230 of the Communications Decency Act is going to give them immunity for any of the content that was provided by a third party. One exception to Section 230 is with respect to intellectual property rights, but in this instance, I don't think there's a good argument that the parents of the woman who was shown in the photo own the copyright to the photo. If that's not the case, then I think Section 230 is going to protect Facebook for any liability that would otherwise attach. The more interesting part of the case to me is the desire or the need to obtain the identities of everyone who viewed the photo. And it seems to me that if it was a matter of merely trying to establish some form of damages, that numbers would be sufficient. But I don't know and this is a plaintiff's lawyer in New York who has some level of fame or infamy, depending on how you believe, which side of the story, with respect to some of his past activities with regards to judicial screenings and the like. But the fact is that it seems to me to be fishing for new potential defendants, and I'd be interested to see what potential causes of action one would have against someone who merely passively looked at a photo on Facebook.
Yeah, that does seem like a stretch. Yeah. Iyaz, any thoughts on this one?
Yeah, if terms of service couldn't protect Facebook, wouldn't this argument prove entirely too much? Wouldn't like every site not be allowed to have any photos of anything in fear of being sued for having a photo like this up there?
Well, they would, and that's why Section 230 was enacted, and it was to protect this sort of feeling that the internet is this, either depending on how you look at it, either the wild, wild west with no rules, or it's an area, a town square that is entirely protected and where the free expression of ideas is encouraged amongst the populace. So, to hold Facebook liable under these circumstances would do exactly what you suggested, which would be to curb the ability of these forums or portals for people to communicate to provide that service to internet users.
I just think it would basically shut down every photo sharing site ever existed, and I don't think that's going to be something that's going to be allowable. I think it's just the argument is interesting, but suing Facebook is like effectively suing the internet.
Right. Well, let's go to that exception to Section 230 for a moment. Suppose there wasn't any controversy about the plaintiffs actually having the right to sue over this photograph. Evan, is this a problem with Section 230? Its carve out of IP, or can sites like Facebook adequately deal with this through their terms of service?
I suppose you could deal with it, through the terms of service, but without something clear like immunity from suit, which is what Section 230 gives us, there's still then this real factual determination that would need to be made as to whether those terms of service are indeed going to make the intermediary, namely Facebook in this case, not responsible. Because you can sign a contract with anyone and disclaim whatever, and you can say even that a contract can't be modified except through writings signed by both parties. I'm making an allusion, subtle or not, to another story that we may or may not have time to talk about. But contract interpretation and the way that they apply to bind the parties and establish the legal relations between them can be extraordinarily complicated and involve a lot of, here we are talking about expense of litigation and headache and emotional costs and all of that stuff. And so terms of service may, in an ideal world and in a frictionless vacuum, be great for managing liability. But when there are real disputes and there are real photos of real deceased people being uploaded to the internet, plaintiffs' lawyers get pretty excited and don't really care too much about what, the terms of service might say. They're going to sue regardless. And my golly, they're going to go in there with a strong hand and fight for justice and what's right and all of that stuff.
Well, I wonder if in this next story you could throw in suing over pictures of deceased pigs to the claims that could be asserted against these folks. I'm hoping Burke has queued up for us a video called 3 Big Pigs. That is a parody and political commentary that got posted to YouTube. I'm not quite sure how it came my way. It is from a YouTube user named Ergo's Gun. I'm not even going to try and pronounce it. Let's let Burke play it. 3 Big Pigs. Are you ready, Burke? There it goes. Do we have audio? Perhaps we don't have audio. So I'll narrate it a bit here. It's Angry Birds, basically, featuring Muammar Gaddafi. There we go. There's our audio.
It's a good thing the audio is helping us understand it.
Well, the audio is from Disney's 3 Little Pigs.
Uh-oh.
Okay, so watch what happens here at the end. The mighty eagle sweeps in. Takes care of Muammar. So.
Oh yeah, I recognize that now.
So I remember how this came my way. Someone tweeted it and wondered if the comment on it was, "Watch it quick before Disney takes it down," because we've got the 3 Little Pigs in there, and of course, obviously, Rovio might have some kind of claim too. I put it on our Facebook page over at facebook.com/thisweekinlaw and asked people to offer a fair use analysis vis-a-vis Angry Birds and the 3 Little Pigs audio. Andrew Thompson said, well, the video's transformative political commentary. It should pass fair use muster. I can't imagine Rovio or Disney sicking the lawyers on the YouTuber, but as the video gains popularity, it could get mistakenly taken down over a DMCA request. I think it uses maybe not all of the audio from 3 Little Pigs, but a good chunk of it. And it certainly doesn't use the entirety of Angry Birds either. I don't know. As with most fair use analyses, I'm on the fence about this one. It's impossible to make a definitive call because you don't know what a court's going to do. What do you think, Iyaz?
Anytime you use anything from Disney, I would panic. That's usually what that's my. I mean, there's fair use and there's all those nice rules when it comes to that. But you step on the mouse's toes and they come at you. So I don't even. I'm not going to even pretend like these guys aren't going to get in a little bit of trouble.
Right.
There is an interesting little potential copyright twist to this. Webby in the IRC is suggesting, and I don't know, I'm not this much of an aficionado. He's suggesting that the song is Prokofiev, the composer, if indeed that's true. And then remember, so then that, the composition for that would probably be in the public domain. Let's just assume that it is. So then say what?
But not the sound recording.
Well, are you sure? I mean, because this was a sound recording before 1972.
Oh, then I'm not sure.
So it wouldn't be under federal copy. Maybe they would have something under like the state of New York. I think that there's state copyright. There's protection for copyright for audio recordings pre-1972 under state law. There's at least one case from New York that says New York will recognize that. So maybe we don't even need to get to the fair use question if we could show that because of its age and its nature in the sound recording, there's no infringement in the first place. I don't know. I was thinking out loud.
That's a great point. That's an awesome point.
I loved being able to show this, Evan, because it's another great example of, a wonderful remix found in the wild and featured on our show so that we could talk about how great they are and how legally dicey they are. Jonathan, want to chime in on this one?
Denise, I think, fair use analysis is always very difficult because it's a case-by-case review. But I think that under these circumstances, I think it's clearly satire or criticism or comment. And I think it should be considered fair use.
Yeah, the Mighty Eagle at the end is just the best. My son recently discovered the Mighty Eagle in Angry Birds and has never since been happy, before or since been happier. So let's get on to our resources and tips of the week. I've got a couple of both. The one resource is perfect for April Fool's Day. It is from the Manpower blog, BLAWG, and it's titled How Not to Get Sued on April Fool's Day. So it's a list of the April Fool's Hall of Shame, as he calls it. And things that, if you're going to play April Fool's jokes on people, particularly in the workplace, some pretty commonsensical advice he's got here. Like, for example, don't spray someone with high-powered compressed air because you could actually kill them. Don't give away a Toyota and then try and pass off a toy Yoda as the prize because someone might sue you for breach of contract and fraudulent misrepresentation, that kind of thing. So on April Fool's Day, I figured that was a decent tip. And then another tip would be, I just wanted to pass along because I think it's perfectly legal and we don't necessarily give a lot of how-to legal tips. But I did want to let our viewers and listeners know how when we're prepping for the show, we get around the Wall Street Journal's paywall. And the way I do that when I need to share Wall Street Journals and the journal stories and the entirety of them with folks on the panel and the viewers and listeners of the show is I use Google. And it's a good commentary, reflection on the uneasy relationship between big media companies like News Corp and Google. Because while the Wall Street Journal does just about everything they could possibly do to lock down your access to their full text stories, they don't prevent Google from being able to link through to them. So if you have the name of a Wall Street Journal headline, the name of a story, or some text from the story. Now, the Wall Street Journal tries to keep you from doing this because if you go to their site and try and copy and paste text, all you get is a bunch of gibberish. They scramble it so that you can't just copy and paste it into Google. But if you can compel yourself to type in a few sentences of text and then search, you get a Google search that then, when you click through, will take you to the full text of the article. And again, that's probably just a temporary thing. Things don't stay online through the journal for that long, but long enough so that we can prepare for the show and have you folks look at what we used to prepare and discuss. So that's my legal way around the paywall. If you can get through it on Google, there's we're absolutely circumventing no copy protection to get you there. So there you go. Have at it. Finally, our resource of the week is courtesy of Eric Heels. And let me just get myself back to it here. It is a perfectly non-April Fool's sort of guide that is what all smart companies should know about intellectual property. It's in our discussion points at delicious.com/thisweekinlaw/episode 105. And Eric has some great points on everything you should know about IP, copyright, patents versus trade secrets. Very good primer if you're a small business to make sure that you are taking care of your IP concerns. So we thank Eric, who's a frequent guest on the show, for our resource of the week this week. And with that, folks, we'll go ahead and wrap up. I want to go around once more and see if you guys have any final thoughts for the day. Iyaz?
I just had a lot of fun listening to you guys, talking with you guys, just bringing back this part of my brain. So it was a nice bit of education. Thanks, guys.
It's a pleasure being able to chat with you today, and as it was yesterday on TNT. So thanks so much for joining us and your great thoughts and insights.
Thank you.
You're the Iyaz, just the only one and only Iyaz on Twitter, right?
Well, there's another guy. He's a singer, and I get confused for him a lot on Twitter only because I look nothing like him. You can find me on Twitter. I'm at Iyaz, and you can see all the stuff I jabber about there.
Great. And tell us, since we've got you here in the chair, and I'm sure people are curious now that you've moved and are part of TWiT, what your role is going to be.
I am the associate producer / host of Tech News Today on 3 days a week right now. And,
Great show.
Thank you. I really like watching it, and I somehow wound up going from the chat room to the actual show. Not exactly sure how that happened, but it's a blast. I mean, I get to help prep the show and help write parts of the news views, and that's pretty much what I do.
Yeah, I remember Jimmy Kimmel when he used to call in to K-Rock. He was just some random listener who would call in and do sports commentary for them. He told them, hey, you don't have a sports guy, and I'm pretty good at it. And they would just put him on the phone with the radio hosts, and now he's got his own late-night talk show. So we look forward to your rapidly proceeding career.
Thank you so much.
Jonathan, great to have you back on the show.
It was a lot of fun.
Wonderful. And your e-commerce blog is an excellent place for information and updates on everything related to technology and e-commerce law. You're Jonathan Frieden, Frieden, on Twitter, and no H in the Jonathan. Anything else you'd like to share with us before we wrap today?
No, that's it, Denise. Thanks a lot.
My pleasure. And Evan, great to have you back on the show.
Hey, well, thanks. I had a great time, and I was hoping that we could make some kind of, big news announcement how, like the EFF and Jonathan's law firm have joined, and they're now representing, big content in mass, suits against BitTorrent users or something like that. That would have been the perfect announcement to make on April 1st. But too bad we can't do that. But in any event, it was fun talking with you, Denise. Always fun talking with you, Jonathan, and great to meet you, Iyaz. This has been a really fun conversation. I hope it hasn't been too traumatic for you, Iyaz, getting back to that legal portion of your brain. But it was tons of fun. I think we covered some great issues today.
I had a great time. Thank you.
Right on.
We did, and we even have more left over for next week of great stories. If you want to check them out, go check out our delicious links. I have to say a huge thank you to Evan. This is what a gentleman Evan is. He gets pinged by Jackie Chang to talk about this Amazon case this week, and he sends it over my way and says, maybe you want to chime in on this, Denise, which I was happy to do. So that was so sweet, Evan, and it was great fun talking with her and wrapping my brain around that controversy, which I'm not sure I would have done to such an extent if I hadn't had to give Jackie something cogent to say about it. So thank you so much.
It's always fun to have those little challenges, isn't it?
Yes, exactly. And of course, you can find Evan at internetcases.com, and he is Internet Cases on Twitter. And there is an Internet Cases Facebook page that has all kinds of great updates and information, facebook.com/internetcases. So
yes,
with
thank
that,
you.
We'll say goodbye, and we'll see you next week. Be safe out there on April Fool's Day. No high tension compressed air, hopefully, will come your way. Take care.